Hi, I'm Aaron Kendall, an estate planning attorney here in Michigan. Today's question is, how do you transfer real property after the title owner of the property has died? And the answer is, with proper planning, it can be done pretty easily. However, if there is no plan ahead of time, it can become more difficult. The best way to do this is to have the property in a trust with the title owner, the trustee, while they're alive, and then having the property move based on the trust to whoever the owner wishes it to go to. If you don't have a trust, the next best step would be having a will, and in the will stating who would inherit the property. The problem with this measure is that the property will have to go through probate and the probate process. This will take around 6 months to do so, and then the property will be inventoried and there will be a property fee charged by the probate court, and then it can be transferred to the person designated by the person in their will to receive the property. But what if there's no will? Now it gets more complicated. It may be a case that it will simply be transferred again through probate to the descendant of the property owner. Again, there's very little choice at this point because there is no will or other directives that would be followed. This could mean that, for example, if there are multiple children, the house may be inherited by them in equal shares. This can create multiple problems in terms of who actually gets the house. Does one of the children have to buy out the other? And many other issues that can arise. And again, since there is no will, there's no clear directive. Now, there are other methods. For example, a ladybird deed can be done to transfer the property upon the death of the current owner, and that's one easy way to avoid probate. However, it's not very flexible, and it's not as useful as having a trust. Another method that is generally not recommended is for the property owner to name another person as a joint owner of the property, and when the person dies, all that the joint owner has to do is file a death certificate with the court and the Register of Deeds, and then have the property inherited. The problem with this method is it does open the current owner to claims against the joint owner of the property and can lead to multiple other legal disputes as well in terms of the house, and it's really not the preferred method of transferring property. If you do have questions about transferring a property, if someone you know is deceased and they're on the title to the property, or if you'd like to plan ahead and make sure that the property is taken care of, please let me know and contact me at kendall-law.com or join my Facebook group, Michigan Estate Planning and Asset Protection, and I'd be happy to help you. Thank you.